The following BLTV program is brought to you by O'Flaherty Law. Please enjoy.
Welcome to Learn About Law. My name is Kevin O'Flaherty from O'Flaherty Law. I hope you find this video and podcast helpful. If you need some help, please feel free to call us at 630-324-6666. We offer free consultations in many areas of law, and we have several geographic locations for your convenience. We serve all of Illinois, and we're also happy to meet with you and provide most legal services virtually without requiring you to leave your home. Enjoy the video.
Hello, this is Matt with Learn About Law, and in today's video I'm going to discuss the recent updates to the Illinois Eviction Moratorium and the Federal Eviction Moratorium. I'll go over the Federal Moratorium effects to the Illinois Moratorium and any changes to the procedure of evictions in Illinois. You may have heard that news that on August 26, 2021, the U.S. Supreme Court issued its ruling in Alabama Association of Realtors versus Department of Health and Human Services. This case was filed by the Alabama Association of Realtors. They, along with other plaintiffs, obtained a judgment from the U.S. District Court for the District of Columbia, vacating the moratorium on the ground that it is unlawful. But the district court stayed its judgment while the government pursued an appeal. The district court produced a comprehensive opinion concluding that the statute on which the CDC relies does not grant it the authority it claims. In other words, that the CDC overstepped the limits of its power without congressional authority. The U.S. Supreme Court held that the CDC has imposed a nationwide moratorium on evictions in reliance on a decades-old statute that authorizes it to implement measures like fumigation and pest extermination. It strains credulity to believe that this statute grants the CDC the sweeping authority that it asserts. The CDC relied on 361A of the Public Health Service Act for authority to create and extend the eviction moratorium. Originally passed in 1944, this provision has rarely been invoked, and never before to justify an eviction moratorium. Regulations under this authority have generally been limited to quarantining infected individuals and prohibiting the import or sale of animals known to transmit disease. The Supreme Court concluded that the sheer scope of the CDC's claimed authority over 361A would counsel against the government's interpretation. We expect Congress to speak clearly when authorizing an agency to exercise powers of vast economic and political significance. Some would say this opinion was politically charged, a conservative Supreme Court versus liberal executive and legislative branches. But what does this mean for the land of Lincoln? Well, not much. In our last article, we explained that on August 20th, 2021, the Illinois Eviction Moratorium was extended to September 18th, 2021, with a struck-down federal CDC eviction moratorium in pieces. The governor decided to act separately. The governor's office now states that when the current executive order banning eviction ends on September 18th, it will be extended to October 3rd. But what has the Illinois Supreme Court done? On August 30th, 2021, the Illinois Supreme Court updated Supreme Court Order MR 30370, the order that governs judicial process regarding evictions here in Illinois. The Illinois Supreme Court held that effective August 1st, 2021, all cases are subject to a stay on all motions, trials on the merits, or judgments in any residential eviction proceedings against a covered person, unless that person poses a direct threat to the health and safety of others or is an immediate and severe risk to property. Now, however, the stay against a covered person can be lifted if the landlord files a motion and proves that a rental assistance program has denied the tenant's application as a result of ineligibility, incompleteness resulting from the tenant's failure to complete the tenant's portion of the application, or exhaustion of available program funding. Or B, that the tenant has not applied for rental assistance and has expressed no intention to apply. Or C, the tenant has applied for rental assistance but is clearly or demonstrably ineligible for rental assistance from the program. Or D, the tenant's declaration making them a covered person is materially erroneous, such that the plaintiff or landlord can prove that the tenant does not qualify as a covered person. This order was set to expire on September 18, 2021, but as we stated above, it will likely extend to October 3, 2021. Most landlords are waiting for the end of the Illinois moratorium to evict non-paying tenants, but unless all four factors can be shown, it will be very difficult to evict a covered person. Evictions are a highly technical aspect of civil real estate litigation. Without a knowledgeable attorney on your side, getting a tenant out of your apartment or defending yourself against a crazy landlord can be an exercise in frustration. So please, call us for a free consultation. Thanks for watching. To learn more, check out the article linked below. Be sure to leave any questions you have in the comment section, and subscribe for more legal content daily.
Hello again, this is Kevin O'Flaherty from O'Flaherty Law. I hope you enjoyed the video and podcast. If you did, we'd love it if you'd subscribe to our channel. If you need legal help in this or any other area of law, please do not hesitate to reach out and schedule a consultation. Most consultations are free and all can be conducted remotely if you'd like. Please email us, book online, or call us at 630-324-6666. We have many locations for your convenience and we serve all of Illinois. So thanks again for watching.